Good morning, everyone. It is 10:08 a.m. and I'm going to convene the informational forum for the Government Oversight Committee. It is Thursday, February 13th. It's 10:08. And just wanted to remind folks the sort of safety issues in the room. We have two doors, two exit doors over there. If there is an emergency or any sort of alarm, please walk quickly to the nearest exit. And after exiting the room, go to your left and exit the building by the main entrance or follow the exit signs of one of the other exits. Please quickly exit the building and follow any instructions from Capitol Police. Please do not delay. And with that, I am going to ask if any of my co-chair and rankings have any comments. I see we have Senator Gadkar Wilcox on the Zoom. I know she's balancing a few meetings that she has this morning. Senator, would you like to make any comments?
No, thanks.
Excellent. Thank you so much. Great. See you in a few minutes. I know our rankings are coming, but they might be a few minutes late. With that, I am just going to jump right into the speaker today. We have Russell Blair, the Director of Education and Communications from the Freedom of Information Commission. Thank you for coming today and looking forward to this wonderful presentation. Thank you for the time.
Thank you so much for the invitation. Also joined here supporting me, Paula Perlman, Managing Director at the FOI Commission, and Max McCann, one of our attorneys. So I've got a presentation that I'll be sharing. So while I get that situated, again, thank you so much for the invitation. It's great to be here, and I really want this to be an opportunity. If anybody on the committee has got questions, more generally, before we get into the public hearing about the specifics, I think this would be a great opportunity to address those, and also to talk a little bit about some of the different aspects of the Freedom of Information Law, a little bit about the history of the FOI law, so people can understand, what the commission does, what our role is, and all of this as you're, debating the many issues before you. So just very briefly on the history of the Freedom of Information Act, 2025 is actually a very important year for FOI, and that is because we're going to be celebrating the 50th birthday of the passage of the Freedom of Information Law. So for those of you who did not know, Connecticut has had this law for 50 years. It's one of the strongest open government laws in the country. And really, it is about transparency of government meetings and government records. What you see on the screen is the preamble from the Freedom of Information Act as it was written back in 1975. And really what it's about is about providing access to information so people can understand the decisions that their government is making, whether that's decisions that are being made up here at the state capitol or decisions that are being made in cities and towns across the state or different departments of state government. The law is really about transparency. It's about access. And I like to think of it as putting the citizenry on the same footing as the people who are making these important decisions about, expenditures of money, decisions about education. It allows for public access to that information so people can, participate and be informed if they want to come to public meetings, if they want to write letters to the editor. For journalists, certainly this is a strong tool that they can use to try to uncover issues in different communities. So, it's about opening up our government, opening up our books, opening up our meetings, to the public. Couple other points of note on the history of the FOI Act. One thing I do a lot of trainings, and I always like to mention this just because I think it's kind of interesting, is that the FOI law actually passed the State House of Representatives and the State Senate unanimously before it was signed into law by Governor Ellegrasso. So, there's a history of strong bipartisan support of the Freedom of Information Act. Connecticut's law remains a model for really the rest of the country and even throughout the world. There have been delegations from other countries that have visited the Freedom of Information Commission in Connecticut to learn about, our law and what it does. I actually had a professor email me on Tuesday who's doing a comparison of some different state open records laws. So, they wanted to reach out and learn what Connecticut does. So, Connecticut remains a model across the country. And you see, about 10 years ago, there was a review of public records laws across the country, and Connecticut was one of just 3 states that scored higher than a D plus. In that particular ranking, maybe they were hard graders because they gave Connecticut a C. So, maybe some room for improvement there, but it just shows that, Connecticut's law is seen as a strong open records law. And, one of the reasons I think Connecticut's law is seen as so strong is because we have a really powerful enforcement tool in the Freedom of Information Commission. So I also want to talk a little bit about the FOI Commission, what the Freedom of Information does and the commission does and sort of how we operate. So the Freedom of Information Commission, we are an executive branch agency, but we really do have a lot of independence in a number of ways. So we have 9 commissioners that are appointed by the governor and the General Assembly. No more than 5 of those commissioners can be from the same political party. So we've got a, commission that has a lot of diverse viewpoints. We have commissioners who have come from a journalism background. We have commissioners who have come, from the background of being practicing attorneys. We have commissioners with backgrounds in town government. So state government. We've got commissioners that really bring a wide variety of backgrounds and views to the issues that come before them. We are a small agency. We only have 18 staff members, mostly attorneys, that act as hearing officers and hold contested case hearings. If somebody appeals, a decision by a municipality, perhaps to deny them access to certain records, or there's an issue that arises where they are denied access to a public meeting. By statute, the FOI Commission is empowered to investigate any alleged violation of the Freedom of Information Act. So whether that pertains to a public meeting or that pertains to a request for public records, we are an administrative appeals agency, so people can come to us and they can file a complaint. We have different abilities to hold hearings. We have the power to request that municipalities submit records to us where, we may do a review of information and determine, what lawfully can be disclosed. We got 855 such complaints in 2024. So, you can see for a small office, we are quite busy, but I think the good news, to communicate to certainly the cities and towns out there is that, of those 855 complaints the commission received in 2024, about 2/3 of them were resolved, through our ombudsman mediation program. So even when a complaint gets filed, not every single complaint necessarily goes to a hearing. Sometimes we'll work with the parties through education. Sometimes the parties through the process will recognize that maybe they made an error and they might, voluntarily agree to rectify that, going forward. They might commit to making some changes. So of those complaints that we receive, sometimes, we're able to address those issues, without requiring, a contested case hearing where the parties have to come before us. But sometimes not, sometimes there are legal disputes, and that's really what the commission is there for, is to resolve, sometimes those hard decisions about what can be disclosed, what can't be disclosed. Does a particular exemption to disclosure apply to a particular record? We have 50 years of case law. We have commission decisions that have gone as high as the Supreme Court. So, that we have a body of law that we operate on. And, one of the good things I think for folks to know out there is that because we do have all these cases, if there's a situation that's arisen in a particular city or town or state agency, there's a good chance that something like that has happened previously, and there may be some guidance that we would be able to provide, based on a past decision of the commission. Another thing I really want to emphasize too is, our education and training, and not just because I'm the one that does it, but, I think it's important for everyone to understand that, the other role that we serve, beyond just adjudicating the cases is, we do a lot of public education. In 2024. We had 125 educational workshops across the state. Some of those are done via Zoom, but a lot of them, are out in the community. So if there's anyone listening here, if your city or town is interested in having a training workshop, if they've got questions, there's an issue that's bubbled up and they would like for somebody from the commission to come out to their community and speak with folks, I'm always happy to do that. even in the evening at a board or commission meeting, if that's what works best. We always try to accommodate those requests for trainings, and also just if there's general queries that people have, maybe they're considering starting a new committee or something, and they're wondering what the FOI implications of that would be, or there's a question about a certain record and there's a concern about what can be disclosed or not. We're happy to try to provide guidance, provide informal advice, and try to direct cities or towns in what we feel is the direction the law goes. Certainly, formal complaints, are dealt with through our contested case process. So, there is a formal process, but also, before it gets to that point, if people have just general questions or concerns or looking for help interpreting a statute, we're always happy to provide those types of answers. And then I thought it would be helpful too to talk a little bit about the way the FOI appeal process works, so people kind of understand, at what level does it go from the city or town, to the commission, and sort of how does that process work? So under the Freedom of Information law in Connecticut, requesters have to request the records that they're looking for from the agency that maintains those records. So if somebody, wants to request records from, a police department, they write an email or a letter, or they could go in to that police department, they request those records. How that public agency responds to that request initially is entirely up to them. They get to make the decision about what to disclose. Certainly this is all governed by statute. There's laws about what you have to do in the process, and the timeliness of responses is a thing that's called promptness that I can touch on in a second. So, this is governed by law, but the process of how it happens is really handled at the local level. So what that means is public agencies, they're the ones that are really in the driver's seat when they get an FOI request, at least initially. Now, if the person who requested those records, gets a response back that they feel is incomplete, maybe they think that there were things that were withheld that should not have been withheld, or they think that, the city or town did not do a thorough enough job searching for the records. Maybe the city told them we don't have any information, and they believe that there are records that are not being provided. Or somebody could file a complaint if they have not received the records yet, and they believe the response was not prompt. The law requires prompt production of public records by public agencies, and that is very fact specific. So, there is not a universal timeline to respond to an FOI request. It really depends on a lot of various factors about that request, including the size and scope of the request, other agency business that is pending at that time, the importance to the public of completing other agency business. Our courts have said that FOI is a primary duty of public agencies, but also, cities and towns have a lot of other obligations and a lot of other business they have to attend to. And I don't think anyone expects that they're going to stop doing everything else they need to get done, just because an FOI request comes in. But really the challenge is the balance. When I'm out training in municipalities, we talk a lot about that, about trying to find that appropriate balance to making sure that, you're providing prompt access to public records as required by law, but you're also making sure that you're doing all the other important things that need to get done in your city or town. But if a requester is aggrieved, they think things are withheld, they think the timeline wasn't appropriate, they can file a complaint with the commission. And then the commission will open up a case to look into what's happening. We will look and see what records were disclosed. Was there anything that was withheld that should have been provided? We can examine the timeline of the response. Was that appropriate? Was it prompt or not? And then we issue a decision on our findings. And those decisions are written by one of the attorneys in our office who would oversee a hearing in that case. And then they go for a vote before our full commission. So there's a lot of opportunities along the way for somebody who's involved in that process, whether it's a requester or a city or town, to make their case. They can make their case before the hearing officer. If the report comes back and they're not happy with the outcome, they can, come to our commission meeting and they can make their case directly to our commissioners. And, if the commission upholds that decision and they still think that it's not proper, they can file an appeal in Superior Court, and those cases will go all the way to the Supreme Court if necessary. So a lot of the guidance and, guidelines in case law about FOI, a lot of that has been driven by Supreme Court decisions. So there is a really strong ability to review this. The FOI commission does not get the final say if somebody wants to go to court to challenge a decision of the commission. So I think that's important for everyone to understand, the role that we play in this. But again, even the work that we do, there's a mechanism where people, if they have a question or a concern about a decision, they could go seek judicial review in the courts. So with that said, a little bit, the overview of the commission, I want to get a little bit into some of the specifics about the law. What is a public record, cover a few of the exemptions, and then certainly save some time at the end for anybody who has any questions about any of this. So you see there the definition of what a public record is under the Freedom of Information Act. And I think the key phrase there I've underlined is relating to the conduct of the public's business. So that is really what makes something a public record under the FOI law is it's information pertaining to the conduct of the public's business. It doesn't matter whether it's an email, it doesn't matter whether it's handwritten, it doesn't matter whether it's a video, body camera video, for example. Those are public records that are available under the FOI law. So if it's records dealing with the public's business, including correspondence, emails, text messages, dealing with the public's business, then it is a public record that's available under the Freedom of Information Act. However, as you probably know, there are exceptions and there are exemptions to disclosure under the Freedom of Information Act. And that's really what that second paragraph is about. Except as otherwise provided by any federal law or state statute, all records are maintained or kept on file by any public agency or public records that are available for inspection or copying. But again, except as otherwise provided by any federal law or state statute. So what that means is, there could be an exemption to disclosure that is in the Freedom of Information Act. And some of those we'll address in a minute. Or there could be other state statutes, and that is very common. There might be a particular program that's established, and there's statutes when that program is created that deal with what can be disclosed and what cannot be disclosed. One of the examples I like to give when I'm out doing trainings is, everybody who's got a driver's license in Connecticut, there's a photograph of you, right? When you go and get your driver's license renewed, they take your picture. So the state has got all these photographs of all of us. Those are public records. They are not widely available to the public under FOI because in the motor vehicle statutes, there's language that deals with who can get access to those and how they can be disclosed and so on. So, it's important to understand that the sort of the body of law of FOI is not just what is in the FOI statute. You could read the FOI statute up and down, and you may not find something dealing with a particular issue, but that could be because it might be addressed in another statute. And one of the challenges that I run into training is that there's not really one list of all these out there. It would be nice if there was, but because they are all so contained throughout many different sections of the Connecticut general statutes, there's not just one area that deals with non-disclosure. And sometimes it's not even that the law makes something prohibited to everybody. There might be a mechanism where a certain person can get access to those records. For example, if you're familiar with our erasure statute, if you have a criminal charge and it gets dismissed, the records get erased. The police department cannot disclose that information any longer. However, the subject of that erased record can still get access to that. So if you get arrested and your case gets dismissed, you can still get information about your own case. So it just goes to show you that, even with some of these exemptions, there's sort of more nuance into who can get access to a certain record or not. So as I stated, there are 28 exemptions within the FOI Act. There's a listing of some of them: trade secrets, attorney-client privilege, adoption records, records that pose a safety risk. Law enforcement has a lot of exemptions. And then again, there are countless other statutes that provide for exceptions to the Freedom of Information Act. There's one dealing with the evaluations of public school teachers. There's one that deals with information relative to child abuse. That's found in the Department of Children and Family statutes. There's a whole procedure that deals with ethics complaints filed at a local board of ethics, and there's some confidentiality in the beginning of that process prior to a probable cause finding. So again, there are numerous statutes outside of the Freedom of Information Act that have a big impact on what can be disclosed. So safety and security, I think it's important to talk a little bit about this exemption because a lot of times when new exemptions are proposed, I think this is a thing we commonly hear is, we are concerned about the safety of a particular person. We're worried that disclosing this information is going to, put somebody in harm's way. And, the commission certainly understands, the concerns about that, that there could be a disclosure that could result in safety risk, and we don't want to see that happen. However, there is a pretty strong tool already in existence in the Freedom of Information Act, and that is there's an exemption found at Connecticut General Statute 1210B19 that says any public agency does not have to disclose information when there are reasonable grounds to believe disclosure may result in a safety risk, including the risk of harm to any person. So this could be, safety risk about an individual. It could also be, safety risk about a facility. If somebody was asking for, security plans about a building or something like that. And the way that the reasonable grounds are determined is the public agency really consults with another agency that has some sort of security expertise. So at the state level, that's the Department of Administrative Services. I dealt with this very recently on a case that I was working on where, the Department of Public Health got a request for some information. I believe it pertained to public drinking water. They were concerned that there was a safety issue. They went to the Department of Administrative Services. The Department of Administrative Services reviewed it. They told DPH, you don't have to disclose that information. DPH went to the requester and told the requester, hey, we got this determination that this is a security issue. And in that case, the requester who had filed a complaint with the commission withdrew the complaint upon receiving that letter. So, there's an example of how that safety and security process can play out at the local level. Instead of DAS, they would go to the state police. They would go to DESPI and say, we've gotten a request and there's some information in here. We're concerned about disclosure. DESPI would review the situation. And again, if they agreed, they would tell the town that you don't have to disclose that. And it's important, that consultation, because if the requester filed a complaint and wanted to challenge that security determination, those security experts would be part of that process. They would have the ability to come to a Freedom of Information hearing and testify. In the public health example, DAS would be able to testify if that complaint had gone to a hearing about the concern about the safety of drinking water if certain information is disclosed. And you see in there a citation from a case that dealt with this exemption, and it just shows that really, the commission is going to rely on the expertise of these security officials. To my knowledge, I don't think we've had a situation where, a public agency has gone through this process, found something that was exempt based on security issues, and the commission has overruled the judgment of the security experts. You do have to go seek that determination, and it can't be something that is, entirely frivolous, but it is something that the commission would give a lot of weight to. So with matters in safety and security, I think the commission believes there is a strong exemption that exists in the law, and it was, intentionally written in a broad way. Reasonable grounds to believe disclosure may result in a safety risk. It's not particular to any one instance, so the safety risk could deal with a number of different instances or categories of records. Then to give you just some examples of this in action, I mentioned the one that we had recently with public health, but that PETA case, that went all the way to the Supreme Court, and UConn did not have to release the names of certain animal researchers to PETA because there was a safety concern. We had another case, these were ones that didn't go to court, but one involving the New London Police Department. They didn't have to release certain records to somebody who was incarcerated for homicide because there was a concern about, maybe potential retribution. And then another one, again, dealing with, sort of public water infrastructure. There was a situation in the town of Darien where somebody was requesting certain sewer maps, and there was a concern, I think, because there was information on the sewer maps that was sort of tied into, again, the public drinking water infrastructure. And so they sought the security determination, and the commission said they did not have to disclose those particular maps. So in law enforcement records, again, I think this is a good example of where, the law seeks to really balance transparency with privacy. There is broad access to police records through the Freedom of Information Act, but there's also protections in place. There's exemptions that deal with, witness information, juveniles, victims, and there's also an exemption that, allows law enforcement to withhold information if it would be prejudicial to a pending law enforcement action. So, if they're concerned that releasing something would compromise their ability to make an arrest, there's an exemption that would allow for that information to be withheld until, that arrest is made or that search warrant is executed or, that subject is interviewed, whatever it is that they need to do in the course of their investigation. But on the flip side of that, there's another section of the FOI Act, Connecticut General Statute 1215, that says once an arrest has been made, there is some requirement of minimum disclosure of information. So if somebody gets arrested, they have to release the blotter information about the arrest, and they have to release the arrest report or the arrest warrant affidavit, again with certain information redacted. And body camera, I think, is another example of where this balance has been struck. Body worn camera is available under FOI. The state has a body camera law, so all police officers now have body cameras. So somebody can request body worn camera footage. However, there are provisions in that law that say they don't have to disclose videos of minors, people undergoing medical treatments, scenes of certain, crimes, domestic violence, sexual abuse, homicide, or suicide. There's also provisions in there, if a video captures an officer when they're on their break or they're engaged in their personal activities, those videos don't have to be disclosed. So, when that law was crafted, I think there was a balance that was struck there about, allowing public access to videos, recognizing the interest the public would have in the work of the police, but also, protecting individuals who are involved in the police because they're, involved with the police because they're a witness, because they're a victim, and also protecting the officers if they're in a personal situation and they just leave their body camera on, they're not going to have to disclose the videos of those types of situations if it doesn't deal with a particular case or a particular investigation. Some additional exemptions, just I think important to note, personnel or medical files. This exemption deals with the personnel or medical files of public employees. So public agencies don't have to disclose any information that would constitute an invasion of personal privacy. So personnel files are available under FOI. People can request records contained within personnel files of public employees, but you don't have to disclose anything that would be highly offensive and does not pertain to a matter of public concern. So certainly things like medical information, medical records, those types of things, don't have to be disclosed under the Freedom of Information law. And the law also has a mechanism where, the employee whose records are being requested can also get involved in the process. And so the way that works is if somebody makes a request of a public agency, if somebody, went to the FOI commission and requested my personnel file, right? They want my entire personnel file. Somebody at the commission who is going to handle that request would have to look through the personnel file, see what is in there. And if there are records in there that they believe, would pose an invasion of personal privacy, then they would come to me and then I would have the ability to issue a written objection. And I could say, no, I don't want these items in my personnel file to be disclosed. And upon receiving that written objection, the agency doesn't disclose that information. If the requester still wants to pursue it, they would file a complaint with the commission. And ultimately what could happen is the commission might privately review those records and make a determination about, what would be disclosed. There's a couple exemptions that deal with legal matters, really to protect, public agencies and allow them not to have to disclose their legal strategy, whether that's records that pertain to strategy and negotiation about a pending claim or pending litigation. Disclosure is required once the litigation or the claim has been adjudicated or settled. So it allows for confidentiality, while that settlement might be happening, but the settlement itself, would be a public record. Attorney-client privilege, that applies in the world of FOI. So this includes, any legal advice that's given in confidence or communications that are made to a government attorney in the furtherance of legal advice. So there's a strong protection there for legal matters. And there's also an exemption for trade secrets. Sometimes we see this come up where, there might be a concern about new and emerging technologies, and maybe the government is serving some kind of regulatory purpose. And we maybe, the government may be requiring businesses to submit financial information or submit, information about their products or their services for a governmental purpose. And then the question is, well, now those records are under the auspices of FOI, and what would stop a competitor maybe from learning about this program because they've got to submit things to the government? Well, the trade secrets exemption is really intended for that. So it's intended to protect the trade secrets of businesses that maybe they have to share with the government for a particular purpose, but this doesn't mean that their competitor could file an FOI request and obtain that information and then, develop their product in such a way that it's going to impact, the ability of that business to succeed. A couple other matters, just want to touch on this one because it deals particularly with legislators. I thought it might be of interest. And this is a declaratory ruling the commission issued a number of years ago. So this was not a specific case that came before us, but it was rather more of a question. We don't do these all that often any longer, but there is a process where, maybe if we don't have a particular case, there's a way where, we can examine an issue and issue something a little bit more formal than, just guidance. So in this case, the issue came up about, correspondence that you all receive as legislators and what would have to be disclosed under the Freedom of Information Act. And the way that the commission looked at this was they made this distinction between correspondence to or from constituents that is directly or indirectly related to enacting legislation or making laws. So if somebody writes to you and asks you to support a bill, or somebody writes to you and asks you to oppose a bill, things that are dealing with legislation and lawmaking, those correspondence are considered to be public records under FOI. However, emails or correspondence that you receive that is more about, maybe what we might consider constituent work. Somebody has an issue with, Department of Social Services, and they reach out to you, and they might be sharing information with you about their case, and they're asking if you can help, and maybe you're able to refer them to somebody. These things that are not dealing with something that is before the legislature. It is not about enacting legislation. It is not about making laws. It is more about, hey, can you help me out with this personal matter? Those types of correspondence are not considered to be public records under the Freedom of Information law. So this was this distinction that was drawn up, when this issue came before us. So I think that's important for everyone to know with your own correspondence, that there is sort of these two buckets of lawmaking and more of kind of constituent casework type of records. So proposing new exemptions. One thing I think we always try to impart, through our testimony at public hearings and otherwise, is that, oftentimes, like we talked about with safety and security, the first thing we suggest is if there's a concern about certain information, the first thing should be to look at the existing exemptions and see if there might be one that applies before, a new exemption is created. There's a 50-year body of law between the Freedom of Information Commission and the courts. Some of the issues that you may be concerned about, it's possible that there's been a case or there's been a decision, on that very point. So, even if you don't find something specific in the statute, there might be a Supreme Court decision where they've said, these types of records are covered by this particular exemption. If people have questions about exemptions, again, the commission is always happy to discuss those issues, and to try to help to make better legislation. Vexatious requesters, I think this is another important thing to touch on. I hear this concern from cities and towns, and there is a mechanism in the law, this was put in maybe 6 or 7 years ago, that allows for a public agency, it's almost like a reverse FOI complaint. Instead of somebody filing a complaint because they don't get records, a public agency can file a complaint with us and say, we've got somebody who, we believe is abusing their rights under the Freedom of Information Act. And potentially, if the commission determines that somebody meets that standard, the relief we can issue is we can tell that municipality or that state agency they don't have to comply with any future requests from the requester for up to a 1-year period. The term vexatious requester is not defined in the law, but it does outline that, what the commission has to consider. So we look at the number of requests that individual has filed. We look at the scope of the requests. We look at the nature and the content and language or subject matter of the request, as well as other communications that they have sent to the agency. And really what we are looking at is, we're looking for a pattern of conduct that amounts to an abuse of the right to access information under the FOI Act, or an interference with the agency's operation. So certainly, the public has the right to request records under the Freedom of Information Act, but agencies also, have a lot of other obligations. They've got a lot of other business that they have to attend to, and the law is about requesting records. It's not about abusing public officials in that process. And so, this, law sort of seeks to provide a mechanism where a city or town, if they have somebody who they believe, again, it's not about requesting information anymore. It's become an abuse of those rights. It's become an interference with the agency's operation. They could file a petition with the commission. We would review that, and then if we determine that there's enough evidence to move forward, we would hold a hearing. The person who is being having the petition filed against them, they would have the ability to respond, to defend themselves. The town or city would have the ability to put on evidence about the person's behavior, and we would have the ability to issue that order that they need not comply with requests for up to a 1-year period after that date. And then this is just the last slide I just want to end on, and then happy to take any questions folks have. Just some excerpts from some different court decisions about the Freedom of Information Act. Again, the Freedom of Information Act expresses a strong legislative policy in favor of open conduct of government and free public access to government records. The general rule under the Freedom of Information Act is disclosure, with exceptions to the rule being narrowly construed. And this one I already mentioned, I think, is that an agency's FOI duty is a statutory duty or command. As such, it is not second class to any other statutory duty or command. So, FOI is a primary duty of public agencies. The challenge that I hear all the time is about trying to balance FOI with everything else that is ongoing. And I certainly understand how that can be difficult, in a municipality or in a state agency, particularly with limited resources. But I think, it's important just to step back and remember, the law is about providing access to information. It's about transparency. It's about holding government accountable. And again, I think there's a strong process in place where, if a city or town receives a request and they have questions, we're happy to answer questions. If they feel like that they shouldn't disclose something and they deny the request, there's the appeal process through the commission. So there are a lot of different tools and mechanisms to try to find the best way to handle a particular request that comes in. But with that said, if people have questions, I'd be happy to address them. I really want this to be an opportunity for you to get any answers to anything that you may have lingering.
Thank you so much for the presentation. I know there are some questions and some people are on a time crunch. So I'm going to defer to our ranking senator, Senator Sampson, to jump in with his questions.
Thank you very much, Madam Chairman. And good morning, Russell. I appreciate you being here. I found myself jotting note after note. I have a lot of simple questions, really more than anything.
Sure.
I appreciated your comments too about checking with FOIA before we decide to put in legislation. Maybe I'm probably guilty of putting in bills without asking first, and I'll try and make a point of being better about that in the future. A few things that you mentioned that are pretty interesting. The first one I wanted to ask about was the legislator email correspondence, that sort of thing. I was surprised to find out that items having to do with constituent service are not subject to FOIA, when in fact they are having to do, generally speaking, with government agencies, that sort of thing. But my question is really something a little bit different, which is about unsolicited emails and texts and things like that. I tell people in this building constantly to use my official CGA email address, but they have my personal email. Mm-hmm. And so I'm forever getting, official correspondence to my personal email. I don't answer it. I make it go to, I just go through the proper channel. I'm just wondering if that ends up being a FOIA issue at some point, if you have your personal email and you're receiving items, even if you're not answering them.
Sure.
Through you, Madam Chairman.
Thank you very much.
So, this comes up a lot in municipalities, particularly for folks who serve on boards and commissions where they don't have maybe an official email. They're using, their personal email. So if you receive or send emails on a personal email and they deal with public business, those are public records. So, somebody can make an FOI request of somebody, on a board or commission or in state government. And, if they're using a different email account to conduct their public business, somebody can request records, and they would be, that person or that agency would be obligated to search not just the state email, but also, any other accounts that they use. When I do my trainings for state employees who I know everyone has an email, I really urge people to, conduct all your business on your state email. That doesn't mean necessarily that every single email is going to go out under FOI, but it means if a request comes in, it's a lot easier to find the universe of records that may have to be disclosed versus, having to go and search through a Gmail account, that might mean an employee has to do that, individually because the IT people can't access that. So if it deals with public business, if it's on a personal email, it still is a public record.
Thank you. Senator Sampson.
Thank you, Madam Chairman. Sorry, trying to use protocol and go through the chair as like we're supposed to. So through you, Madam Chairman, just another question, which is, one of the proposals that I see every year in this building, and I serve both on GAE and this committee, is the non-disclosure of residential addresses. And we've had proposals that cover just, small groups, maybe folks that work for the Attorney General's office, all the way up to proposals that make it wide open, or rather cover all state employees. I'm just looking for maybe the commission's view on why we have the standard that we have. And historically, I think that the commission opposes these expansions, and so have I. Really, I have a kind of a sense that, public employees, when you sign up to work for the state government, you're signing up, to make your information public as well. Just looking for a little more information about why we draw the line where we do, and your thoughts about some of these bills. And we have those bills in this very committee, as a matter of fact. And it's kind of ironic in my view, because this is the Government Oversight Committee, and we're actually talking about limiting the public's view of government. Through you, Madam Chairman.
Thank you very much, Mr. Russell.
So I'll be testifying later on the specific bills too. So, but to speak, more generally, I think one of the things that the commission always tries to address when these issues come up, well, to your first point about, the origin and kind of where the list started, it predates my time, obviously, at the commission. And I think, my understanding is, that provision was put in when we kind of lived in a different world where, you couldn't, there wasn't an internet. There was not a way where people could go and could search names of individuals. And I think that's one of the things the commission has always raised, is that, that protection in some ways gives people a false sense of security. And, in a couple of ways. One, as I just mentioned, people can search and they can Google, and, if you haven't done it to your own name, you should try it, and you might be surprised at just how quickly, you could locate your own address, through a simple Google search. And there's, firms out there that, will give far more than that if people are willing to pay. They can find out far more information about somebody through a simple search. The other thing I think is important to know with that section is that it does not apply to all public records. Specifically, voter records are exempted from that. Land records are exempted from that. Tax records are exempted from that. So, while, if you know what town somebody resides in, but you don't know, their individual address, there are still records that are going to have that information on there. I have had situations, because again, I deal with our public question calls, where somebody who was in one of those protected classes, went to the town hall, filled out the form, I don't want my address to be disclosed. And the town clerk had informed them, okay, just understand this doesn't apply to certain records. And they called me and they were complaining about, wait, what does this mean? I thought this meant that if I fill out this form, my information is not going to be available under FOI. And I had to explain, well, certain records, your personnel records maybe, or maybe a dog license with the town clerk. But there's other records where it is going to be available. So I think that, that's been one of our concerns, is that it really doesn't, I think, provide the protection that people think it does. And then I think the other issue, that we grapple with every year is if you're going to propose expansions of that, where do you draw the line? I saw even in the testimony on the bill here today, about the teachers, there was questions about other school staff. So it's a hard issue to deal with, but I think primarily we want people to understand that it maybe doesn't go as far as people think it does. And I would hate for people out there in the public to think that this means that their information is totally hidden from the internet, of the town is never going to disclose anything with their address on it, because that's just not what the statute does.
Thank you. Senator Sampson.
Thank you again, and through you, Madam Chairman. I appreciate all that information, Russell. I mean, it makes sense, and we've heard the same thing over and over. I'm just curious, getting to the point, what is the actual principle involved with whether or not we're going to disclose someone's addresses or not? I mean, the argument to shield those addresses is the safety of the state employees, especially if they work in a department that might have constituents that are upset for whatever reason, because it has to do with DCF or disciplining a student, like we mentioned with teacher or something. So I'm just trying to wrap my head around, at some point we said we are not going to, or we are going to disclose these addresses because these are government employees. The public has a right to know. And over time, we have decided to shield some of them. But I think the original principle was lost. And you gave a very fine answer. I'm not criticizing your answer at all. It just was more about, well, they can get it somewhere else, and it's not a very complete. But, for me, when I vote on things, I like to do it based on some sort of value and principle that I can say, well, the reason why we don't disclose these addresses or we do shield these addresses is because. And I don't mean to bug you. If you have any thought on that, I'd like to hear it through you, Madam Chairman.
Thank you, Senator. Mr. Russell.
Yeah, I think there are numerous times when, an address, could be important. In my former life, I was a journalist, and, if you get somebody, let's say you read an arrest report and there's the name of somebody on that arrest report, and, that is the same name as somebody who is a public official or in a public position. One of the ways you might verify that that is the same person is to look up, the address and ask that agency, hey, is this the address of the principal of the high school, right? Because there's an arrest report, the name is the same, but if you're a responsible journalist, you're not just going to go run off and publish a story if you don't verify that it's the same, the same individual. I know an example that's been raised before is, and I believe it was in the testimony from the Connecticut Council on Freedom of Information, Melissa McCaw, who used to work in state government, took a job in the city of East Hartford, and, through having her address available, people were able to look up the Journal Inquirer, I believe, and find out that she had outstanding property taxes. And then the town of East Hartford made her pay those property taxes as part of, before she took employment in that town. So, for purposes of verifying, who somebody says they are, the address can be, very important for that. You're seeking to figure out if somebody has the correct license or something like that. There's a lot of occupations that we have where people have to have particular licenses. You may want to verify that, that individual is the same individual who holds a certain license. So, I think there are, examples of where, that information could be, very relevant to a particular request. So, I think I think that's the answer you're looking for there, about more specifically about, when you might use it.
Thank you, Mr. Russell. Senator Sampson.
And thank you again, Madam Chairman, and through you. I appreciate that. That's a little more what I was looking for, is kind of just to get a gist of, why have that policy altogether. I have just one final question. It has to do with a bill that I've got proposed. And I did it on behalf of a constituent because, and it's something that comes up pretty often, which is the timeline for when someone should expect to get a response for a FOIA request. And I'm just curious if there are any standards, and do they vary? Like we would expect to get something from, a municipality in a certain amount of time frame, or it might be take a little bit longer if it's going to be a more involved request. I mean, what determines whether or not it's a reasonable time frame, and then how is that enforced? And that's my final question. Thank you, Russell, for being here. I appreciate all the information today.
So the legal standard is what's called promptness, and that is fleshed out in an advisory opinion the commission did a number of years ago. And so to your question, it may vary. What is prompt under the law, and there's no specific time frame. It may vary from town to town or agency to agency because it's really fact specific. So we would look at how large the request is. So larger requests, there's more time allotted versus a smaller request. Also, other business that agency has. If an agency has, police department has 50 other FOI requests they've got to get done, that's something that we would take into account. If a requester feels like the town is taking too long, they can file a complaint with the commission. So the commission, we don't just deal in, in terms of somebody did not get the records. They could also file a complaint because they haven't received anything yet, or they haven't gotten a response. They could file, what we would call a promptness complaint. And then the commission would, ask questions of the city or town and the requester, and, delve into the timeline and what was going on at the agency at the time, what other business was there ongoing. And then we would make a legal determination about whether the response was prompt or not. And, if we found that they weren't prompt, we could find a violation and we could issue an order. Perhaps, we would say that they would have to disclose any remaining records, within a period of 60 days or within a period of 90 days. So if people are experiencing, not just that they're being told no, but if they're experiencing, delays in records requests, they could also file a complaint with the commission.
Excellent. Thank you, Mr. Russell. Thank you, Senator. I have a couple questions. We are due to start our public hearing at 11, but I'm going to defer to my co-chair here for any questions that she has before we jump into that.
Thank you so much. And thank you for being here this morning. I was listening in the car on the way up. So I was teaching class. So I apologize for not being here. And just want to start by saying, I appreciate all the work that you do, because transparency and accountability are two sides of the same coin when it comes to good government and good governance. And so I really appreciate that. And then as a constitutional person and a First Amendment scholar, I appreciate sort of the access to information and the work that you're doing. That being said, I have a couple of questions about maybe picking up on what Senator Sampson said about the justification around things like addresses, for example, because there has to be, and I appreciate what you said, that there's some value in being able to locate addresses and that they're publicly available. So you're giving people sort of a false sense of safety. But then there was also some justification for exempting groups already, like police officers, for example, right, who may face a different kind of danger or safety concern as a group, sort of categorically, which is perhaps why I'm presuming they're exempted, plus other groups. So there's a bill before us and a request by a number of teachers that have been facing, they're saying the same kinds of sort of fear of retaliation, disgruntled parents coming in. So I guess my initial question is, why is that address, especially since the flip side of what you said is, since this information is so readily available, why is it so important that when a parent files a claim, they're able to access a teacher's address if they're a disgruntled parent, given sort of that maybe there's an increasing risk at this moment to teachers? And are those usually the times when we start creating exemptions, like for police officers? So I just wanted to talk a little bit about what value really does it add, since the school can get access to that record, that the public needs to access just the address piece, not other parts of FOIA records.
So I think one thing that's really important to note is that, again, given that there's a broad exemption for safety and security, if a district got a request from a disgruntled parent that was targeting a specific teacher, I want to know where this teacher lives, and they believe that, they were alarmed by a request like that, there's a mechanism existing in the law where they could go to the state police and they could say, look, we got a request from somebody who is disgruntled with a staff member, and they're asking where that person lives, and we don't feel comfortable disclosing that. And there's a process in place, where, they could seek that security determination. I think the specifics of the request might be important, and maybe that's part of the reason why you have an exemption like that versus just saying a certain address is always going to be off limits in all cases. I mentioned a couple of examples of where it might make sense. Maybe if it's a reporter who's saying look, this is the same name of somebody who was arrested, and that's the same name of a school staff member, and they're trying to call to verify an address, so they're asking for the address for that purpose. Maybe that's different than a disgruntled parent and there's a safety and security concern. And again, I think it's hard to put yourself in the mind of somebody who's trying to obtain that information, but my guess is that if the school district told them no, I don't know that would prevent them from finding that information in another venue, and it could be through an FOI request for another public record that has that information. So I think that's why we always try to emphasize that this isn't as complete and total as it is, because even if the bill that's been proposed passes, there are still going to be other public records that are going to have these addresses of these educators that are going to be available under the Freedom of Information Act. So it doesn't maybe go as far as people might think it does.
No, I appreciate that. But presumptively, that's true for all of the groups that were exempted. So police officers, for example, they would also be able to apply for the safety and security exemption, but you created a category of exemption. Presumably, I presume you can explain to me, if not, that as a group, they face a higher risk. And so we're not going to go through the individual. So I guess my question is, if we start seeing sort of a trend of data where teachers are providing, or school districts are providing evidence that there's sort of this increasing risk, would it be appropriate then to say, as a group, perhaps there needs to be a categorical exemption?
I mean, I think more, examples are always helpful. I'll say from, my own experience, it's not something that I have heard, not saying that I hear everything that goes on with FOI, but, it's not a concern that I've heard from a lot of, school districts, at this point. The other thing with the addresses too is, I kind of mentioned this earlier, but I think, that law was put in place when the world was a lot different, and maybe the public records at your job were one of the few places where your address was readily available. And I think that, like with everything, they had to make a list and they had to try to pick people who, they determined were maybe at that time were most, most at risk of having something happen to them. A lot of them are people involved in the criminal justice and, judges and the judicial process. But then we hear a lot of different arguments from a lot of different groups about the issues that they also face. So I think that's the hard part is sort of, in the beginning, I think it was a little bit different because some of these other people, if you were a teacher and there was no internet, people probably were not, able to find your address as readily available as they are today. So, I think it was, put in there at a time when the world was a lot different. One of the other things that, I've mentioned before, is that, in terms of addresses, I think the protection of our addresses has even changed. The phone book used to have everyone's address and it would just get distributed across the city or town and you could look up anyone's address. And, we've sort of changed our idea of, what is acceptable and what isn't acceptable. And I think that law was, put in place at a time when it maybe made sense. And it's a little bit different now. And we're still adding to the law that was sort of created at a time when maybe things were different, and again, I wasn't here when it happened and it predates me, but I think it was, the law itself is a little bit outdated, and by adding more people to it, we're giving them this protection that maybe is, doesn't address some of the other concerns that are being raised. Perhaps there's another legislative way to address some of the other concerns that are out there that the non-disclosure of addresses, doesn't fully address.
Thank you very much. And I have just one question on another topic about, if there's any way to track the number of FOIA requests that have been made, and if those have been sort of increasing recently over time, because a lot of this sort of runs on the presumption that people are acting in good faith when they're looking for information. But there's also the other side of that where people may just be acting to be disruptive or to get to, and we're seeing maybe a weaponizing of FOIA, which then does become overly burdensome to whatever local districts have to produce all this information, perhaps repeatedly. And I know you said there's some point where it gets to vexatious litigation, but I'm wondering about that point in the middle where, towns are sort of facing this increasing request for FOIA, maybe not always for the right purposes. And how does that get handled? One, I just want to know if there's any way to track that. Like, is that true? Is there a trend? Is there data on like how often people are filing FOIA and how much these requests have increased or not over time?
So, the only thing at the commission that we would have is, we track the people that file complaints. So we know the volume of complaints that we receive and the subject matter of those complaints. But unfortunately, there is no, sort of clearinghouse of tracking FOI requests across the state because every agency deals with their own FOI requests. So every city or town, certainly cities and towns may have those statistics. So, if there was a way to ask cities and towns, what they're seeing in terms of the number of FOI requests and if that's been increasing, State agencies, a lot of state agencies have moved over to this online platform that's called GovQA. I imagine through that platform, there might be a way where they can, extract some of that data, and it might be easier because it's already on a, system. But, some of the small towns, the FOI requests, it might be something that comes in the mail, right? And so I don't know how they track the number, and, our law doesn't really require a certain tracking or accounting of the FOI requests. We're concerned that people respond appropriately, but, we don't really track them. Certainly we can, anything that comes to the commission, we know the topics and the volume and that sort of thing. And, we did have a larger number of complaints than usual last year, but part of that was because we had one complainant who brought a lot of complaints about a similar request. So that sort of pushed the numbers up a little bit for last year.
Thank you. I'm going to recess this information hearing for a minute. And I am going to convene the government oversight Thursday, February 13th, 2025 public hearing. I'm going to go back. So we're flipping. Okay. So I'm recessing the informational hearing.